Up next, what's an initial status conference? Now, you can find more in the book on page 36, but generally an initial status conference is an informal meeting with the court. It's not a hearing, so you don't present evidence or testimony or witnesses or anything like that. It's actually relatively short, typically about 10 to 15 minutes. It can take a little bit more time if you have complex issues or interpreters, but generally it's short and quick. Now, during this meeting, you're going to talk about a few things. For example, where are you at with your financial disclosures? And did you file your sworn financial statement if you have finances related to your case? And also, have you completed your parenting certificate and your parenting class? Now, all of that stuff is included in your case management order, which I recommend you read. Now, also, you're going to talk about experts. Do you need one? Do you have a house that requires an appraiser? Do you have custody disputes or high conflict that's requiring a child family investigator? The court also expects you to talk about these things with the other side, and you may not like the other side, but you have to make good faith attempts to try to work some of these out. And at the end of the day, it's better for you and for the court the more agreements that you have. Now, if you haven't completed your 16.2 disclosures and sworn financial statements, the court may give you an extension, but I wouldn't bank on that, and I would come prepared. So budget your time, and the book also talks about sworn financial statements and how to complete them. Now, you're going to probably get a mediation order, and mediation is required in almost all family law cases except for emergencies and other matters in which the court waives it. So be prepared for that. And also be prepared to talk about any emergency issues or urgent issues that you think the court needs to address immediately. Now, if you're filing for the first time for a divorce or custody, you can ask for a temporary orders hearing, but typically the court will also order you to go to mediation before that temporary orders hearing. Now, this varies by jurisdiction, so some judges will allow temporary orders hearings to be set without mediation being completed first. Temporary orders hearings are hard, if not impossible, to get in post-decree motions. So if you're filing, for example, a motion to modify parenting time, it's unlikely that the court is going to grant you a temporary orders hearing just because you already have orders in place. Now, it doesn't hurt to ask the family court facilitator at the initial status conference if you can get a temporary orders hearing in a post-decree case. And also be aware that certain jurisdictions, you may end up meeting with the judge for the initial status conference. For example, in Denver County, if there's lawyers on both sides, the judges prefer to do the initial status conference themselves. So with that, I think you have a lot on your plate. Take it one at a time. And if you need more help, there's more guidance in the book. Good luck.